Hello everyone, and welcome to this webinar on Israel's judiciary. This webinar is brought to you by the Nazarian Center for Israel Studies at UCLA. I'm Dov Waxman, the director of the Nazarian Center and the Rosalind and Arthur Gilbert Foundation Chair of Israel Studies at UCLA. I'm delighted that this event is also co-sponsored by the International and Comparative Law Program at UCLA. Our speakers today are Menachem Hofnung and Nir Atmor. Menachem Hofnung is a professor in the Department of Political Science at the Hebrew University of Jerusalem and is currently a visiting professor at the UCLA Nazarian Center for Israel Studies. Professor Hofnung has served as the academic director of the Gilo Center for Democracy and Civic Education, and he's been a president of the Association for Israel Studies and of the Israeli Law and Society Association. He's also been a member of Israel's National Commission on Campaign Finance Reform and the National Commission on the Structure of Governmental Administration in Israel. Nir Atmor is a lecturer in the interdisciplinary department at Zefat Academic College in northern Israel. His areas of research include Israeli democracy and comparative politics. He's published several books, including Electoral Systems for Democratic Legislative Bodies in 2010, and he's co-authored a series of books on the Israeli Democracy Index. He's also authored Voter Turnout in Israeli General Elections, which was published in 2015. He's received his PhD in political science from the Hebrew University of Jerusalem, and they are the co-authors of the research that they will be presenting today. I want to encourage you all to send us your questions using the Q&A box on your screen, and we'll leave plenty of time for Q&A at the end of their talk. So without any further ado, let me turn over to Professor Hofnung and Professor Atmor. Thank you.
Thank you very much. We are both delighted to be here, and we like to thank the Nazarian Center and Dov Waxman for arranging this talk. I would like to turn now to our subject of today, which is public trust in Israel judiciary, the effect of political polarization. And I will start by saying that as social scientists, we have noticed two processes. One is that over the years, especially because of the public opinion surveys held by the Israel Democracy Institute, that trust in the judiciary is coming down over the years almost constantly. And this is in spite of the case that in the last couple of years, the court is trying to refrain from making sweeping decisions. We also noticed that there are continuous political attacks against the court, especially in times of elections. And therefore, we have decided to look if there is a connection between the two, as trust in the judiciary coming down because of the court decision, or it is tied to other processes in Israeli politics. Now, the structure of the presentation is the following. I will start with historical analysis of the Supreme Court rulings on public disputes and matters related to the political process. Then Nir will present the quantitative analysis of public opinion on trust in our court, and then we will finish with finding as conclusion. I will say that during the presentation, I will only refer briefly to court rulings, but in case you like to bring questions about specific court rulings or examples, we will do so in the Q&A after the presentation. The question that we ask in our presentation is first, why the powers of the court become such a center of political conflict in the Israeli political system? Can we identify support and opposition to the court among distinct groups in the Israeli public opinion, which means, is it possible that different groups treat the court differently? And is this conflict belongs to something which is much greater, and this is ideological polarization of the entire political system. Now, as we mentioned, the historic part of this one, we start in 1948 when Israel was formed. If you look at the situation in 1948, when Israel came into being, there were very few checks and balances. There was supreme authority resided in the legislature. There is only one legislative branch in Israel. There was a parliamentary system in which the executive is not separate from the legislature, but it controls the legislature. The prime minister and the ministers in the government, they are also Knesset members. So they are part of the executive and part of the legislature. There was no constitution, no formal power of judicial review, no guarantees of human rights, and permanent state of emergency. In another way, it is almost a recipe for a breakdown of democracy. Of all the democracies that came after the Second World War, until the demise of the Soviet Union, the only country that held democratic processes constantly was Israel. All the others, either they faced coup d'etats or other breakdown of democracy. Now, before we go on, we do have to understand the structure of the court in Israel. Israel has a Supreme Court the way that you are familiar with in the United States. It has, the Supreme Court sits at the apex of the judicial structure, and all appeals go to the Supreme Court. But unlike the United States, the Supreme Court of Israel sits in another capacity, and this is a High Court of Justice. This is a method invented by the British mandatory authorities. Take a look at this picture. You actually see one court sitting in two different capacities. While sitting as High Court of Justice on the left-hand side, all complaints against the public authorities go directly to the High Court of Justice, sitting as first and last instance. It is like a court of first instance, but also the Supreme Court. And even without the power of judicial review, it gives the court enormous political relevance, because the court can decide cases in real time. For example, I brought a petition to the Supreme Court 25 years ago. During the elections of 1996, the hearing was held 7 days after I submitted the petition. At the end, I lost the case, but at least it was an interesting case. What is also peculiar about Israel is the method of selecting justices to the Supreme Court. Unlike the US, where it is done by the president, in Israel, there is a committee, and members of the committee come from 4 different constituencies. If you look at the composition, there are 2 cabinet ministers, 2 Knesset members, in most cases, 1 from the opposition parties, 3 Supreme Court justices, and 2 lawyers elected by Israel's bar. Again, if we count the members of the committee, there are 9 members, but the professionals are 5. They are the majority. And the politicians, they do have an input, but they are the minority. Of course, to get nominations, sometimes you do have to negotiate and make a political bargains in which the justices participate, but there is an input of professional qualifications into the nomination. In the first 20 years, and even more so, the nominations to Supreme Court and the name of the justices didn't say much to Israelis. At the same time, the political system was controlled by one party. So elections were held, and parties fought it out, but it was very clear what is the outcome of the elections. Things have started to change in the Six-Day War of 1967, and a few years later, we can see how it has affected the court. So just the headlines. What happened in 1967 is relevant to this lecture, is that after the war, two separate legal systems under one government were created. One for Israelis, including Palestinian citizens of Israel, and the other one is for the Arab resident of the occupied territories, mainly Gaza and the West Bank. And Israel started to build settlements on land that its status was questioned. In many cases, it was expropriated from the local Palestinians. And it had been done by the military authorities in the West Bank and in Gaza. When cases were brought up to the High Court of Justice, the government decided not to dispute the power of the court to exercise judicial review of the decision of the military authorities. And that gave the court much more say in the most crucial public affairs in Israel itself. We move now to the political arena. The Likud party came to power in 1977, and in the next three electoral campaigns held during the 1980s, the powers of the political representation of the two biggest parties came almost in equal numbers. In each campaign, the Dovs represent the left, the Hawks represent the right, and if you can look at this picture, you can see that the swing vote was held by tiny parties, mainly Haredi or ultra-Orthodox parties in the middle. In this situation, politicians found it out that it is much easier to refrain from making decisions, to let the court to decide the matter, because if they make the decision, and I can bring examples later, it means that they may risk the composition of their coalitions, because a party that is not satisfied by the ruling can switch to the other side and change the composition of the coalition. And this is possible in Israel, unlike the US. You can switch sides and coalition can fall and can be brought up even without elections, between the elections. The willingness of the court to look into such matters, sometimes with the blessings of the politicians, also encouraged activists in civil society to bring more and more petitions to the court. And the court started to look at that and make a decision. Now, at the same time, and I'm moving from the political arena to the judicial arena. The three electoral campaigns brought something that resembled the crisis that we face today. After the election, the third consecutive tie between the two parties, there was an attempt to present a new government in the same Knesset in 1990. And this has been done by political defector, switching alliances from one party to the other. At the end, it failed, but the Knesset, facing crisis and protest to clean Israeli politics of corruption and bad practices, the Knesset enacted three new basic laws. And basic law in Israel is almost the equivalent of constitution in the US. And those three basic laws gave much more power of judicial review to the Supreme Court. Now, in that case, when the court started to use the powers, and the most important decisions made during the time of Prime Minister Yitzhak Rabin between 1992 and 1996 were mainly concerning either religious ministers of government or matters that related to religious ideology. For example, one case that made the headlines was a decision of the court to allow an employee, based on the labor agreement of the company, to take his male partner and to enjoy a free ticket. Now, the court presented it as a matter of labor agreement, but in the ultra-Orthodox community, it was presented as a license to have homosexual relations. And those people, mainly, they don't read the court cases. It is brought to them either by the newspapers or by the political leaders. So altogether, it led to a backlash against the court. In the 1996 elections, we saw the first time politicians running not only one against the other, but also against the court. And it proved to be a success because all the parties that ran against the court made political advances. Nir, your turn.
Okay, thank you very much, Menachem, and good morning, and thank you all for being with us today. My name is Nir, and I'm happy and excited to be here. I will present now to the quantitative part of our research, that is based on the public opinion survey that was conducted by the Israeli Democracy Institute. This is the Israeli Democracy Index, which is an annual survey that runs for the last 20 years, every year. Now, the survey was carried out last June 2020, shortly after Israel's third round of elections on March and following the first COVID-19 pandemic lockdown. The survey includes representative sample of Jews and Arabs, and this is an extensive survey that deals with Israeli democracy in general and some questions that deal specifically with the judicial system and the Supreme Court of Israel. Now, our main concern is with the public trust in the Supreme Court, or the question that you can see here, to what extent do you trust the Supreme Court institution? Now, we are using also other questions that appear in the Democracy Index, in the Democracy Survey. For example, how would you define the situation of the judicial system in Israel today? Or to what extent are professional decisions of the Supreme Court justices influenced by their political positions? Now, the next slide, we can see the preliminary findings of our research. Now, when we look at the data in terms of religion, the Supreme Court is at the top among Jews, Christians, and Muslims, which receive very high percentages of trust, approximately 60 or 70%, but not among Jews. And now the question that immediately arises is, why is this so? Or how it can it be? Why is the least of trust among the Jewish public? And this finding leads us to the following slide that deals with the trust in the Supreme Court by political orientation. Now, if we look at the breakdown of the level of trust by the political orientation, this is the scale that you see on the x-axis, the right and the left axis. We can see that the Supreme Court, as an institution that should serve as a keystone in the Israeli democratic system, it earns very high percentages, and 90% of trust on the left, but it earns only little trust among the right-wing sectors of the population, only around 23. Now, this is a constant decline. The more right you are, the less you trust the Supreme Court. Now, in the next slide, in the following figure, we can see that in the last 20 years, this is very constant. And it's relatively consistent, and no many differences have been made. You can see that the right wing give approximately 30, and there is a decline over the years, and while the left wing, more than 80% trust the Supreme Court. Now, when we dig even deeper and look at the polarization in terms of religiosity in the next slide, we can clearly see that the Haredim show very low percent of trust, only 6.3%. Now, at the other side, the secular, 71% are trust the Supreme Court. Now, those numbers express high level of trust among the seculars, while the national religious and the Haredim, the very religious, they tend to trust less the Supreme Court. Now, our next slide shows us the level of public trust by voting behavior in the 2020 elections. Now, here also we can see that the Labor, blue and white parties, the voters trust at very high percentages, more than 80%, while the Torah Judaism and the Shas parties, those are the Haredim parties, only 8.5 and 11.5% trust the Supreme Court. Now, the differences between those is extremely interesting, and when we even go to the next slide, we can see, in the last slide, we can see it's apparent that when we look, the socioeconomic status, we can see that if you are at a very high socioeconomic, you probably give very high trust, about 69 or 70%. But at the other part, when you are coming from the very lowest socioeconomic status, only 20% give their trust to the Supreme Court. Now, if we'll conclude this, higher incomes translated into greater faith in the Supreme Court, while the lowest income level, usually the religious public, only a minority place their trust in the Supreme Court. Obviously, education, political orientation, and even religiosity, as we saw, all which are closely linked with the income level, may serve as a mediating variables affecting the levels of trust. To sum up, in the last decade, we can see repeated attacks by politicians, party leaders, and public figures on the Supreme Court, and therefore the impact of these attacks on the decline of the trust in the justice system cannot be ignored. Thank you very much, and Menachem.
I would have to say that what we can see in Israel is not peculiar only to Israel. We can see that also in other countries where autocratic leaders, and especially popular ones, even in democracies, they can find it very attractive to run against the court and to limit the power of the court. We even saw that sentiment in the US. If you recall, not only the court, but try to remember what former President Trump said about the elections. I will accept the elections, the results of the elections, if I win, not if we lose. And when he lost, you saw the consequences. And in the countries that mentioned here, Russia, Turkey, Hungary, Poland, we can witness a successful initiative to curb the power of the judiciary, install new judges, justices that are willing to go more according to the dictates of the executive. When we look at Israel, this is becoming even more serious because of the trial of Prime Minister Netanyahu. In the first 10 years of his second coming into the position of Prime Minister, starting in 2009, Netanyahu was very silent about the court. He didn't care that much about the court. The initiative were brought by other members of his coalition. But when he was facing a trial, he also started to wage attacks against the court. And this is becoming more and more serious. In the last week or so, for example, when the trial was opened and the evidence and the witnesses are about to be presented, he sent a clear message to the court that if they start the evidence process before the elections, it is a political intervention by the court in the free decision of the people. The Supreme Court, on its part, maintained its impartiality, but it is no longer insulated from political pressure, and it is much more careful in handing down decision. We don't see the sweeping decisions that we have witnessed in the 90s. So if we come towards the end of our presentation, the Supreme Court is much more careful and staying away from making decisions that interfere in the decision of the office holders. Public trust in the judiciary is taking constant sharp down. At the same time, the politicization of the judicial system undermines public trust, not only in the judiciary, but in the representative institution in Israel as well. And altogether, what we can see, and we can elaborate on that later in the Q&A, is a danger to the public trust in Israeli democracy altogether, and maybe making the land fertile for more attacks on democracy altogether. Thank you.
Thank you very much for that informative and somewhat sobering presentation. We have lots of questions coming in, and please continue to send them in. Before I turn to questions from the audience, I want to quickly take the prerogative of putting my own question first. And you showed in the slides that the more secular you are and the more left-wing you are, the more likely you are to have trust in Israel's judiciary. Is this related in any way to the composition of the court? In other words, there's a perception, historically at least, that the Supreme Court justices themselves are secular, left-wing, kind of Tel Avivians, even if that's not absolutely true. Could you say something about how the composition of the court is itself changing, that now the current court has become somewhat more religious? I believe it includes settlers now. So does the composition of the court, who are these 9 justices, does it matter? And how is that changing? How is the composition changing over time?
Yes, I will take it first, and maybe Nir will add a few comments. I would start from a different point of view. When Israel had been created, there was kind of division of labor. All family matters were given to religious courts. If you look at the rabbinical court, it is all the judges who sit there. All of them are males. They are all Haredim, and there is no representation to other groups. At the same time, it had been conceived that the Supreme Court is a bastion of democracy. It should defend human rights. Now, as long as this one is accepted, you can look at the judiciary by itself and say, I can understand that some groups are represented less, while others represented more. About 10 years ago, when the attacks intensified, I came up with an article in the newspaper Haaretz and said, I'm not in favor of applying representation basis to the selection of judges. But if you like to try it, so let's say charity started its own. Why not starting with the rabbinical system? So over there, we put some secular judges. Example for myself, I can be a Dayan, if you like. We bring in women, and then if it works, then we apply the same system into the general judiciary. Of course, the attacks that came on Haredi, websites were harsh. But I would say if you like to apply such a system, let's do it all over the judiciary, not only about the civil one. But it would be another way to look at all the representation. And I don't think that the Haredi and the religious are willing to even think about the idea of having a secular Dayan in the religious courts.
So there is no consideration when the Judicial Appointments Committee meets. They don't kind of try to think about the composition. I mean, we take the US Supreme Court, obviously.
No. I would say it is accepted. They look also into representation of other groups. They make it a point to appoint Arabs, to appoint Mizrahim, to appoint even religious. Actually, if you look at the composition of the entire judiciary, and I've made that statistic, there are more religious judges than their relative share among the population. So they take into consideration. But the idea that you can apply representative quotas to one part of the judiciary and not to the other, I myself, I don't accept it at all. So if you like to apply that quota, so I like to have it over the entire judiciary.
So we have a related question from Neil Diamond, who's asked, how do the justices line up ideologically? Is there a right, left, center divide in the court? I mean, what's the ideological composition? Has it changed over time?
It had been changed. Now, unlike the US, there are some differences. In the US, all 9 justices sit on every case. In Israel, there are 15 judges, and in most cases, they sit in panels of 3. So the composition of a bench in every trial is changing much. Also, the caseload is much higher. The Israeli Supreme Court handles about 10,000 cases a year and write a decision in about 2,500. So it is much bigger caseload than in the US. And therefore, it is difficult to make all the statistics that you can make in the US. But I would say this, in the last couple of years, because of the domination of right-wing parties in the electoral process, they were able to push more and more people who identified with their agenda into the Supreme Court. And I suspect that if the Likud is able to come victorious, and unlike the US, there is a mandatory retirement age in Israel, judges do have to step out when they reach the age of 70. So in the next cycle, we can have majority of justices who were promoted by right-wing parties.
So we have a question that's related to that. I'm going to read it. Demographics show that secular Israel is shrinking by the year. And so how long do you think before the Supreme Court, or can the Supreme Court then be dismantled by the groups, particularly Likudniks, Haredim, who have little, if any, trust in the judiciary? I mean, what is the kind of the possibility that this system could be essentially dismantled or at least undermined?
I don't see it as a possibility in the near future. I think that we'll be satisfied if the Supreme Court is tamed and stay away from politics. Actually, there are many proposals to change either the power of the Supreme Court or to take out of its jurisdiction all kinds of decisions, or to change the formula of selection into Supreme Court. Nobody is proposing to dismantle the Supreme Court. This is not there. But there are all kinds of changes that, if implemented, can make the judiciary different from the ones that we can see now.
In particular, gutting it of the power of judicial review.
Yes.
And trying that way. I know in that context that there was a bill that had been previously proposed, the so-called override bill. Can you tell us something about this piece of legislation? Is it dead? Is it likely to resurface?
It depends on the outcome of the elections, because everybody, including the right-wing parties, they say that they are in favor of making the Supreme Court better, of just changing it for having a better court. Now, overriding, that means that if the Supreme Court strike down a law, the question of how can you revive that law that was struck down as unconstitutional by the court? Do you need a simple majority, because in Israel we have only one house, or you need a special majority? What the right-wing politicians push forward is a proposal that the Knesset can override the veto of the Supreme Court by a majority of 61 members, which is a minimal winning coalition. Other proposals name higher number of 65, 70, 72. I suspect that if something like that is amended, coming into fruition, it will be around a majority of 65, which is much more difficult to attain.
Especially in the current state of Israeli politics.
Yes.
So we're speaking of the current Israeli politics. Obviously, the elephant in the room so far has been Netanyahu's indictments and his attacks upon the court that you mentioned at the beginning of your presentation. So we have a question that comes in from Linda Andron. If Bibi is able to cobble together a coalition, which of course is very much uncertain at this point, but if he's able to do that after the next election, can he get his indictment dropped through the Knesset? And
since I answered all the questions until now, I will refer that one to my colleague Nir, and maybe later I will add something. Nir, would you like to say something about it? Yes.
Well, I think it's too early to call if Netanyahu is the winner, although statistics are saying that he's on the lead. But I think that I cannot answer that yet, because we do not know the results of the elections, of the coming elections. But even that, I think that the polarization is much also from his side of the arena. And we can see that the frequent attacks against the Supreme Court and against the judicial system is something that we can see steadily. And his camp, the ones that trust him and the ones that are voting every year, year after year, because we are in the fourth elections in the last 2 years, we can see that this is something that is constant, and I think that in the long run, this is not something that is going to stop. I mean, probably will continue from, if not from his side, but from the people that surround him, and we might see this coming again and again.
So
I like to add something to that. I think there are few lines of defense on the side of Netanyahu, assuming he is winning the elections. The first priority is to be the prime minister. And he may become a prime minister with a coalition that does not fully support the suspension of the trial. So the second defense is to delay the trial as long as he is the sitting prime minister. I mean, if he can get any allegations against serving prime minister thrown out by legislation, he will do so, despite the fact that last week he denied any intention to do so. Everybody believes that he's going to push forward. But a lot depends on the outcome of the coalition. And there is a possibility that there will be a majority in favor of Netanyahu, but objection within the coalition to make what we call personal legislation. So ask me that question, let's say, after the Passover Seder, when we'll have the final results and we can see a composition of the new Knesset, I will be able to answer that question, with a greater certainty than right now.
Okay, well, I want to. We have some questions coming in about this issue of public trust and the reasons behind the decline of public trust. Oded Haklai, a colleague of mine, Israel Studies professor, asked: Is this decline in public trust a result of attacks by politicians such as Netanyahu and others? Can you maybe provide some examples of these kinds of attacks? And can you see any causal link between these verbal attacks by politicians and declining public and the erosion of public trust?
Nir, you'd like to take it first, and then I will add to that?
Of course. Now, if we try to explain the trust, we can divide the public into two, but not evenly. I mean, at the left side, as we saw before, usually the ones at the center of the political spectrum and also the left wing, they are usually with high tendency of trust towards the Supreme Court. But at the right side, we can see the decline is even bigger at the right side, because about 20 years ago, the most of the population had very high trust in the Supreme Court, more than 80%. This used to be like the lighthouse of the Israeli democracy. And what we saw in the last 20 years, and mainly on the last years since Netanyahu is under investigation and under a trial, etc., we can see that there is more and more decline among the right-wing voters. And this coming from somewhere. I mean, most of it, we can also relate this to the attacks of the political leaders and the other at the right wing, which constantly attacks the Supreme Court. Now, when we look at the long run, this more than 40% or 30 or more percent of the decline is coming from somewhere, and this decline is mainly at the right wing, the religious parties, which less and less support and trust the Supreme Court. Those are the facts. This is the picture. Now, the explanations are from different angles, and I'll pass to you, Menachem.
I will add to that if you try to analyze the cases in which the Supreme Court really intervened in the past, most of the sweeping decisions relate to two areas that are very important to the religious audience. It is the matter of settlements and religious affairs and religious politicians. Now, in that two examples, if you try to put women in religious, not in rabbinical positions, but in religious councils, this is breaking the power structure of the Haredi community. If you make decisions against separation between women and men on the streets, like there were attempts to do so, if you try to intervene in kosher practices, it again goes in this one. Although if you look at how they operate and what they do, you can understand why it is needed to defend civil liberties of people who use and look for kosher. So altogether, it is interpreted by the religious institutions or by the religious establishment to go against the religious people altogether. And again, those people, usually they don't read the decisions themselves. They look at how it is transmitted to them by their own media channels. And therefore, you can see the link. Now, we can present it in a more sophisticated way, but I suspect that if we do that, we are going to lose the audience right here.
Thank you. So we have a question related to the kind of role of the Supreme Court on religious matters, and you mentioned how some of these Supreme Court rulings have contributed to the erosion of trust among the religious public. So what's the relationship between the judicial courts and the rabbinic courts, and the Supreme Court in particular? Is it able to override the rabbinate, or are they kind of two separate judicial spheres?
It cannot, and I repeat, it cannot override the decisions of the rabbinical court as long as they stick to the Jewish halacha. What they can but sometimes it is presented if they intervene in the Jewish halacha. Now, I can give you an example of a leading case that happened almost 60 years ago, but that can give you an example. And it will be maybe more than 1 minute, but it can give you the essence. An Israeli Jew went to Denmark. He met there a Danish Christian woman, and they got married. Now, because he came from a traditional family, he asked that girl to convert to Judaism. And they came to Israel, and she came as a converted Jew. A few years later, he has decided that he liked to break out the marriage. But instead of coming to the court, to the religious court, it is held strictly by religious court. He came to the court and said that the conversion was a fake. And therefore, he is asking for divorce. The rabbinical court is having jurisdiction only when the marriage is by two Jews. And the rabbinical court said she did not convert and therefore they are not married. She went to the High Court of Justice, and the High Court of Justice accepted the petition. Why it accepted the petition? Because once the court could have done two things. If they are Jews, you go according to the halacha, and she has to agree to a get. If she is not a Jew, then it is not within the jurisdiction of the rabbinical court. Now, speaking legally, it is very basic. You don't have jurisdictions over Christians. As the court decided that she is a Christian. In that case, the High Court of Justice can intervene because they stepped out of their jurisdiction. And most cases, when it intervenes in the decisions of the rabbinical court, is that when they don't stick to their limited powers, but they try to make sweeping decisions. Okay? I hope it made the point clear enough.
Yeah, fascinating. So we have a couple of questions that have come in about the legacy of the former head of the High Court, Aharon Barak, perhaps Israel's most famous jurist, the best known, and the one who was most responsible for pushing through this idea of judicial review and an activist court. How is Barak's legacy, Aharon Barak's legacy, viewed today, particularly within the judiciary? How do they see his legacy? And is that still is the court still operating in a sense in the framework that Barak established in judicial review and an activist court, or is it no longer that kind of Supreme Court?
I guess I will start, and then maybe Nir will add something. Barak influence has declined over the years. He was the most influential judge that Israel has ever had. He sat on the Supreme Court for 28 years. Before that, he was the Attorney General. So altogether, it is more than 30 years in the most influential legal positions in the public service of Israel, if you combine the two together. And out of those 30-something years, he was also president of the Supreme Court for 11 years. But he stepped down when he reached the age of 70 in 2006. So he's already 15 years removed from the Supreme Court. And he became the center of attacks against his legacy. It is still a very rich heritage, but you can see erosion and actually people coming out against him more and more. So in a way, it is still there, but much more limited than it used to be.
Thank you. Maybe we have time for a couple more questions. This is a question coming from Byron Cohn, who asks, would the adoption of a written constitution enhance or diminish the standing of the court? I mean, in a way, these basic laws do function as a quasi-constitution, but would the court and the standing of the court benefit if there was a written constitution?
I guess it is a matter of speculation. It depends what is going to be written in the new written constitution. You can say something about the soup when you taste it. And we haven't had a chance to see how rigid constitution looks like. Nir, any addition to that?
Well, I think also that we hadn't have the privilege of having a constitution, a written constitution until today. I think we cannot answer that, unfortunately. Yeah.
Okay, well, let me ask a final question about the impact of the nation-state basic law that was passed and created a lot of controversy and attention in Israel, but also around the world. Based upon your knowledge of the judiciary and of the Supreme Court, what impact is this law having? Are you seeing it invoked by justices now? Is it constraining or changing the kinds of decisions that are being reached, or is it, as some suggested when the law was first passed, more symbolic than actually having a real judicial impact?
There are a few ways to look at it, and they may not lead altogether to the same conclusion. I would say that if you look at the content of the law, from my point of view, it is a disgrace. Simply a disgrace. I mean, the Jewish nation is mentioned there 11 times. No word about equality of citizens before the law. So that gives you the example in a nutshell. Now, whether the court is going to strike it down, it is the most difficult case the court had ever faced. Why? Because it is not only a law, it is a basic law. Now, the question is whether the court can strike down part of the Constitution. Can the Supreme Court in the United States do something like that? I suspect no. I mean, can the court say that part of the US Constitution is unconstitutional? Think about that. And I think that most of the legal scholars here will say no. The third one is, what is the real impact of the law? Not much. It is mostly a declaration. But on the day-to-day life, it doesn't change much of the situation. So I suspect the judges look for the politician to bail them out. What they really like to do is to have a new coalition that amending the law, and then they can say the matter has been solved by the politicians and we don't have to rule on that. It is on the Supreme Court docket now for 2.5 years. I suspect it is going to remain there for much longer time. They simply don't like to decide the case.
Some similarities with the US Supreme Court in that respect then. Well, I want to thank you both, Professor Hofnung and Professor Atmor, for a really informative, fascinating, somewhat discouraging, but really great presentation on Israel's judiciary and the Supreme Court. I want to thank all of our audience for joining us and for sending in your excellent questions. And I hope I'll see you all again very soon. Thank you and goodbye.
Thank you. It has been a pleasure to be here.
Thank you.